Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about a special type of probate proceeding called the disposition of personal property without administration for small estates that have a value of less than the funeral expenses that were paid out by family members. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. So on occasion, I get calls from families who have a very small probate estate. They find out that their loved one had left maybe just a couple $1,000s in a bank account, and they need help getting access to that money. And usually the expenses that were associated with attorney's fees involved in opening up a formal probate or even a summary administration exceed the value of the money in the account. And so when that happens, what we can do is to take a look to see if their estate would qualify for disposition without administration. And many times it doesn't, but I wanted to be able to walk through what a disposition of personal property without administration looks like, so that way you can determine if your loved one's estate may qualify. So first off, the amount of money that's in the, usually it's a bank account, or the amount of the value of the estate cannot exceed the out-of-pocket expenses that the family has paid for funeral expenses and the medical expenses in the last 60 days of the decedent's life. And this can't be prepaid funeral costs. So if your loved one prepaid their funeral, which is wonderful and highly recommended, and you have no out-of-pocket funeral expenses, it doesn't qualify. And if insurance paid for those medical costs that were the last 60 days, it doesn't qualify. So it has to be actual out-of-pocket expenses that the family paid out to have the funeral. And it has to be less than $6,000. Your maximum that this has by statute is $6,000 for this type of probate. So if you had an elaborate funeral that cost more than $6,000, there's a $6,000 threshold. Okay. The other stumbling block that most people have in qualifying for the disposition of personal property without administration is you need to be able to list the person's assets on the sheet, on your petition. And many times banks don't tell you exactly how much money to the penny, which is what you'd want on this petition, is in the account. They'll just maybe give you a window of maybe how much it could be, or they will be completely silent and won't give you any information. So what you really need is you need the person's bank statements. So if they are still a person that gets their statements in the mail to their house, then you are in luck. Or if you happen to have access to their email or their online banking account, because they're the type of person who had all their passwords either written down or saved in their computer, and you can just click and see it, then it'll work out as well. So a review, you have to make sure that the value is less than the funeral expenses. The petitioner has to be the one who paid the funeral expenses, and you have to submit the receipts. And if it's not the person who paid, there needs to be essentially a document that says that the person who paid says that the petitioner can have the money. And if you're looking to transfer a car or other exempt personal property under statute, only the surviving spouse and the decedent's children can make such an application. So if you are in a long-time relationship but were never married, you don't qualify as a surviving spouse, and you can't make that petition for the person's vehicle. And that's basically, in a nutshell, what the disposition of personal property without administration kind of looks like. Many times we find that there's some sort of stumbling block where there's a lack of Lack of information as to the amount in the bank account is a big one. Also, the fact that maybe funeral expenses were prepaid and now we know what's in the bank account and it's only like $2,500, but there were no expenses out-of-pocketed by the family members. And then the costs of probating a summary administration would eat up most if not all the $2,500. So they're going to try to do it themselves or not. But the other alternative would be to monitor the Florida Unclaimed Property website, because after these accounts have been unclaimed for a period of time, depending on the bank's protocols, you might be able to petition the state for the unclaimed property if it's a small amount, whether if it's like $500 or something like that. That might be another alternative to avoid having to go through the disposition of personal property. I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And you're welcome to schedule a free strategy session with me at eldermeeting.com. Thanks for joining me.